Welcome to the official launch of the Press Clause Project Coalition, the logical addition and extension of the Press Clause Project of the Floyd Abrams Institute for Freedom of Expression at Yale Law School. I'm Sandy Barron, a senior fellow with the Abrams Institute and the Information Society Project at Yale Law School. Before we start, I want to thank the New York City Bar Communications and Media Law Committee, and most especially its chair, Ravi Sitwala, for co-sponsoring and being such a good partner on this event, and the City Bar Association and staff for working with us. Auspicious beginning. And I want to thank the Press Clause Coalition partners joining the Floyd Abrams Institute for Freedom of Expression are the Foundation for Individual Rights and Expression, the Free Expression Legal Network, the Knight First Amendment Institute, the Media Law Resource Center, and the Reporters Committee for Freedom of the Press. On the agenda tonight, as I think you all know, but I'm going to say it anyway, will be our colleague Floyd Abrams, who will introduce A.G. Sulzberger, publisher of the New York Times and chairman of the New York Times Company. We're really very grateful to you. We'll work on this fine. See what we do. Your participation tonight. After his keynote, Lee Levine will introduce our panel, who'll be discussing litigating with the Press Clause. Floyd Abrams and I created the Press Clause Project several years ago as a vehicle for exploring how and to what purposes the Press Clause of the First Amendment could be engaged to support and protect the work of journalists and journalism. The First Amendment, as I suspect you all know, provides in relevant part, Congress shall make no law abridging the freedom of speech or of the press. Or of the press, however, has had no particular role to play in First Amendment thinking or doctrine or judicial decision-making for some time. To the contrary, the Supreme Court has too often gone out of its way to state that members of the press are no different from anyone else with respect to rights and protections. Yet for some of us, for a long time now, have thought that the Press Clause was intended to have separate meaning from the Speech Clause, and that there should be recognition that there needs to be unique rights and protections for the functions that journalists perform and that society finds desirable and even critical to the proper functioning of our democracy. The Press Clause Project, with support from the Stanton Foundation, convened 17 workshops around the country with academics and media law practitioners. A report was generated out of the first 8 of those workshops, and an article out of that report was published in the Journal of Free Speech Law, setting out a summary of our findings. In the workshops and our research, we looked specifically at, first, what constitutional work the Press Clause could do to protect and promote journalism, distinct from what it already exists under the Speech Clause. We looked specifically at areas where journalism and journalists are most vulnerable: reporters' privilege, access, news gathering issues, among others. Second, we looked at what constitutional analysis, theories, historical materials could be used to support the right of the Press Clause to play a role protecting and promoting journalism and journalists. And third, we looked at the question of who should be able to benefit from a constitutionally engaged Press Clause, while often shorthanded to a question of who is the press. We found it valuable not to seek a definition for all purposes, but to recognize that the answer to that question might depend upon the specific right or protection being sought. A series of factors was developed and published in our report and in the article in the Journal of Free Speech Law. I urge you all to read it if you haven't already. If you need a citation, just get in touch with me. And to put the work of the Press Clause Project into real-world application, we have now created the Press Clause Coalition, which we hope will be an engine for bringing the Press Clause into the broader legal vocabulary, media law practice, public awareness, and judicial decisions. I will leave it to Lee Levine, who is managing director of the coalition, to tell you a bit more about the work of the Press Clause Coalition. On the scholarship side, the next step for the Abrams Institute is a symposium on the Press Clause in the fall at Yale, in conjunction with the Yale Journal of Law and the Humanities, for which scholarly articles are being written for presentation and subsequent publication. And with that introduction, it is now my honor to introduce Floyd Abrams. Floyd is a renowned First Amendment advocate and known undoubtedly to everyone in this room and on Zoom. The list of Supreme Court cases he has argued on behalf of the press is lengthy, but his advocacy on behalf of the press in articles, books, public appearances, and courts at all levels is truly legendary. He's currently senior counsel at Cahill Gordon in New York. Floyd.
Hello, everybody, and thank you, Sandy, for all that you have done to make all of this possible and so much more. I'm really delighted to have the opportunity just to say a few words to this initial assembly of this group, both to lawyers and others who may have been, I hope, fortunate enough to attend today, and to any, to use an old word, fellow travelers who might be on our side on this issue of making something of a clause of the Constitution, of the Bill of Rights of the Constitution, which has been really astonishingly absent by the Swiss Supreme Court. I joined a group of colleagues who wrote an article published a few months ago called The Forgotten First Amendment. And to a considerable degree, that really is an understated even way of saying that while the press, of course, has won a bunch of cases of enormous importance, thanks in good part to the New York Times and the willingness of other press entities to keep fighting in this area to protect the freedom of the press. Of course, the press hasn't lost all of the cases, but it's not coincidental that great cases such as New York Times versus Sullivan and Pentagon Papers cases were litigated and won by the New York Times. And we can only hope that journalists of this generation, wherever they work, and editors and publishers and the like, will continue to carry on the fight for not just making something of, applying the First Amendment. The problem is that too often, even the Supreme Court has not only ignored it or ignored, they barely quote it, is the truth, but have tried their best to downgrade the notion that the press is something special. I mean, the press isn't entitled to win all its cases, but the press is entitled, and the public is entitled, to have the words, the core of the Constitution applied, and not to be overcome, ignored, or even sometimes disparaged, because that is what has happened too often as the years have passed. It seems to me that the people who litigate cases in this area in the future, and people who are litigating it now, ought to try to make as much as possible about what the framers thought. I mean, we can have arguments about how to interpret a language and, deciding what Jefferson would have done about some device that was unthinkable in the 18th century. The sort of thing you can argue about, but I'm struck by the fact that Jefferson would say our liberty depends upon freedom of the press, and that cannot be limited without being lost. And that he said, if I have to choose between newspapers without government or government without newspapers, I would unhesitatingly choose the former. And why doesn't that persuade judges? It's your fault. No, but it really, things like that, he doesn't enthuse about every cause the way he did about the need to protect the First Amendment. And here's Madison. Madison is the author, the initial author of the Bill of Rights, the author of the First Amendment. This is his first draft. The people should not be deprived of their right to speak, to write, or to publish their sentiments, and freedom of the press as one of the great bulwarks of liberty shall be inviolable. But somehow that has yet to find its way into Supreme Court opinions. And it seems to me it is useful, not just for the Supreme Court, but in arguing cases and trying to get a sort of heft into the press clause of the First Amendment. That sort of historical reality, it's not just advocacy, right? They really believe these things. And while I recognize, as we all do, that doesn't answer every question involving the press doing this or that or saying this or that. But it sets the stage. It is the way that I think the courts ought to begin their consideration of cases in which the press is saying, we need the ability to do this or that, or not, as in New York Times against Sullivan, which of course may yet come up for the equivalent of rehearing anytime in a court which has no particular friendship for the press. So it seems to me that all of us have to do our best to overcome the notion that those of us who wrote the article titled The Forgotten First Amendment, to make it unforgotten and real, and to do all we can to persuade the courts. And as you know, I'm about to introduce A.G. Sulzberger, the chairman of the New York Times Company, publisher of the New York Times. I know it'll shock you to hear that, notwithstanding how young I look now, I worked with his grandfather on the Pentagon Papers case. And I remember learning as we were working on the case how the great journalist James Reston brought up to Mr. Sulzberger's office all the materials the New York Times had supporting not just the reality, but the meaning of the Pentagon Papers. That willingness of the New York Times, at very great risk to itself, in a situation in which its outside counsel declined to represent it in the case is telling and important and impressive. A.J. Sulzberger is now the principal steward of the independence and ambition and excellence of the Times journalism. A graduate of Brown University, a reporter himself for many years. Under his leadership, the Times has been not only a leader, but the indispensable leader of the protection of press freedom in the country. Just last week, filing a case challenging the Defense Department's efforts to not to be seen on issues or heard on issues that this Defense Department disapproves of, and saying that when journalists walk in the building, they have to have somebody with them from them, accompanying them around. That the New York Times brought an action challenging that, having earlier brought another successful action at this time. I wanted to quote as I conclude from an article that A.J. Sulzberger wrote in the Columbia Journalism Review called Journalism's Essential Value. He talked about independence of the press and the need for the press to remain independent of outside governing or limitations. And he wrote that, quote, independence is the increasingly contested journalistic commitment to follow facts wherever they lead. It places the truth and the search for it with an open yet skeptical mind above all else. That said, it is my great privilege to introduce to you A.G. Sulzberger, publisher of the Times and chair of the New York Times Company.
Thank you. It is a real honor to be introduced by, everyone can hear me all right? Okay, great. By such a legendary First Amendment lawyer, someone who's not only fought for many of the most important legal protections for the press, but also happens to have helped keep my grandfather out of jail. So thank you, Floyd. And thank you to Sandy and the whole Press Clause Coalition and the New York Bar Association for hosting me at this event. I'm honored and, to be honest, a little bit surprised that you would kick off such an august gathering of First Amendment scholars with comments from the Wordle guy. But in all seriousness, the project you're launching today is vitally important at this moment when press freedom is facing its most serious test in generations. Too many people today appear afraid to stand up and defend their own rights, core national principles, and the broader public interest. So I'm very grateful that you all continue to uphold our country's foundational commitment to free expression and a free press. We at the Times are lucky to have some terrific First Amendment lawyers ourselves, some of whom are here tonight. I'll just mention David McCraw and Diane Braden. We also have had the good fortune, if not always the happiest of circumstances, of working with many more of you. So thank you for that too. I'm going to try to avoid misstatements of law tonight, largely by avoiding the topic altogether. I know so much less about the Press Clause than Floyd and Sandy and others here tonight. So I'm going to instead focus on why your efforts to strengthen press freedom matter so much and what the Times is seeing on the front lines of this fight. Last fall, the Defense Department issued an ultimatum to the Pentagon Press Corps: sign what amounted to a loyalty oath or get out. Under this new media policy, a reporter who asked questions or who published information that Pentagon higher-ups disapproved of could be arbitrarily stripped of their media credentials. And this attempted crackdown came, as such efforts often do, after a cascade of unwanted headlines. Troubling accounts of the defense secretary's personal conduct, efforts to remake military culture to be less inclusive and more aggressive, legally questionable military actions from Latin America to North Korea to the Middle East. At the New York Times, we regard journalistic independence as central to our promise to the public. We will not compromise our commitment to report without fear of favor. So like every other major news organization, we handed in our press passes. Even outlets openly supportive of President Trump, like Fox News and Newsmax, refused to sign away their rights. And as the press corps was ushered out, a new group of MAGA commentators and influencers were welcomed inside the Pentagon. Pro-Trump firebrand Laura Loomer, the news site started by Mike Lindell, a funder of the Stop the Steal movement, Trump's Attorney General pick, Matt Gaetz, a top Defense Department spokesperson boasted that the press corps swap out would, quote, circumvent the lies of the mainstream media and get real news directly to the American people. The restrictions did not stop our reporting, of course. We've shown that with scoop after scoop, such as the definitive accounts of how Trump decided to go to war with Iran, why defense officials soured on the AI company Anthropic, and the dangerous depletion of U.S. missile stockpiles. But being in the building is important too, and we've viewed the Pentagon's efforts to censor and punish journalists as such an egregious violation of the First Amendment that we decided to take the world's most powerful military to court. Many of our peers argued that, given Trump's frequent attacks on the press, this one was worth letting go. In fact, several told me directly that they feared sticking their necks out would invite retaliation. But rights are just ink on paper unless they're exercised. Standing up for press freedom in court and losing is still a much healthier outcome than standing down and simply letting the administration rewrite the rules. Our country has some of the strongest legal protections in the world for free expression and due process. They mean nothing if the press is too timid to defend them. The judge vindicated our confidence in the law. In March, he threw out the Pentagon media policy and ordered our press passes restored. The legal fight is not over. The administration has appealed and in the meantime thrown up Kafkaesque hurdles to keep our journalists out, requiring us to file yet another suit. But Judge Paul Friedman's opinion articulates well what's at stake. He wrote, "Those who drafted the First Amendment believe that the nation's security requires a free press and an informed people, and that such security is endangered by governmental suppression." He continues, "That principle has preserved the nation's security for almost 250 years. It must not be abandoned now." That 250th anniversary of our nation happens to coincide with the 175th anniversary of the New York Times. I find these shared milestones fitting because the story of our great nation and its most intrepid chronicler, its paper of record, are bound up in one another. America's abiding commitment to free expression and free inquiry has enabled the model of journalism without fear or favor that is key to the Times' enduring success. In turn, the commitment of the Times and other independent news organizations to providing the public reliable information and accountability has strengthened our country and helped it to thrive in countless ways. A free press depends upon a free nation, and a free nation depends upon a free press. Now, that does not mean we have always gotten along with the people running our country. Over the years, we've confronted our fair share of government overreach from left, right, and center. And if you can find the president who didn't want to throttle us at some point, I would like his name. The Lincoln administration censored our founding editor's report on the disastrous Union defeat at Bull Run. Senators upset with our coverage in the lead up to World War I investigated our finances. Local officials in Alabama tried to litigate us out of existence so we couldn't keep covering the civil rights movement. President Kennedy wiretapped our military correspondent's home phone because his reporting on the U.S.-Soviet arms race was too accurate. President Nixon sued to block our reporting on the secret military history of the Vietnam War, known as the Pentagon Papers. The second President Bush warned us that we'd have blood on our hands if we disclosed his administration's warrantless surveillance of American citizens. And President Obama spent most of his term using the legal system to try to force one of our journalists to reveal a confidential source. So on one level, the challenges we face are part of a long, if not exactly proud, American tradition. But it serves no one to sidestep the reality that President Trump has used an increasingly broad suite of tools and powers to go after the press far more aggressively than his modern predecessors. This started as a rhetorical project. As he first ran for office, President Trump called reporting he didn't like fake news. Then came talk of the press as the enemies of the people, an old Stalinist phrase. Then charges that unflattering stories are treasonous or seditious. The legendary 60 Minutes correspondent Leslie Stahl told me that President Trump was explicit about the goal driving this incendiary rhetoric. "You know why I do it?" she remembered him telling her. "I do it to discredit you all and to demean you all, so that when you write negative stories about me, no one will believe you." There's evidence he's found some success. About 2/3 of poll respondents now say they don't trust the press to report the news fairly, accurately, or in the public interest. Many say that they prefer to get the news directly from the president, who has launched his own White House wire, and who one poll found was the top news influencer in the country. But these rhetorical attacks served a secondary purpose as well, laying the groundwork for more substantial actions against the press. Always litigious, the president has grown bolder about turning to civil courts to punish journalists and news organizations. He sued the Des Moines Register for consumer fraud over an unfavorable poll. He sued the Wall Street Journal for defamation over reporting on his ties to Jeffrey Epstein. He sued ABC and CBS and the BBC. His most recent lawsuit against the Times marks his third against us in my tenure. The Journal's suit has been dismissed, and I expect the others that are challenged in court will be too. But some news organizations choose to settle despite the law appearing to be on their side. And as everyone here knows, even unsuccessful lawsuits impose real costs, legal fees, lost time, that may make a news organization think twice about future reporting. These anti-press efforts extend well beyond the courts. The administration has actively used a range of executive levers to pressure disfavored news organizations as well. The FCC has been the most active, launching dubious investigations into supposed political bias at the BBC, NPR, PBS, and CBS following the president's complaints. Its chairman has threatened not to renew broadcast licenses over critical coverage of immigration raids and the Iran war, and even a comedian's joke about the president. At the same time, the administration has effectively steered a broadcast outlet, CBS, and a social media platform, TikTok, into the hands of one of the president's wealthiest supporters, with a cable news channel, CNN, likely to follow later this year. Under this new ownership, CBS has already altered programming, personnel, and policies in ways that more closely align with the administration's preferences. Dispensing with even the pretense of journalistic norms, CBS and its owners recently hosted a party, quote, honoring the Trump White House. Less widely known, but no less consequential, the FCC, with the president's explicit encouragement, waived longstanding limits to approve the unprecedented consolidation of the local TV news market. That company, Nexstar, which would reach 80% of American households, has declared itself, quote, the anti-fake news, among other moves to curry favor with the president. More troublingly still, the administration has shown a great growing interest in using law enforcement powers to aid these efforts too. Other presidents have abused leak investigations to create risk of imprisonment for journalists who refuse to give up their confidential sources, a reminder that this nation would greatly benefit from a federal shield law limiting this type of overreach. Trump has long supported this tactic. Only a year and a half into his term, he and his aides have publicly threatened or pursued over a dozen such investigations into Times reporting alone. The unprecedented FBI raid on the home of a Washington Post reporter and the seizure of her devices, nominally as part of a single leak case, yet with the risk of exposing her entire source network, showed a willingness to follow through on such threats. We're also seeing attempts to directly criminalize the act of reporting. Homeland Security agents have detained, attacked, and arrested clearly identified journalists covering ICE protests. The Justice Department charged journalists with violating federal civil rights laws for covering a protest that entered a Minnesota church. Immigration officials detained a foreign student for over a month and tried to deport her over an op-ed published in the college newspaper. Last month, the FBI took the first steps towards opening a criminal investigation into a Times reporter for ordinary news gathering. At issue was a revelatory story about the FBI director reassigning bureau jets and personnel to ferry around his girlfriend. The purported crime? Interviewing people with direct knowledge of the situation, attending public events, and seeking to speak with the subject. Even after Justice Department lawyers got wind of the inquiry and shut it down, the FBI continued to suggest such reporting efforts had, quote, crossed lines of stalking. Everyone in this room understands that the First Amendment has withstood worse. John Adams used the Alien and Sedition Act to indict publishers aligned with his opposition. Abraham Lincoln shut down newspapers and imprisoned editors critical of his wartime aims. Woodrow Wilson prosecuted publishers and journalists under his newly enacted Espionage Act. But over the last century, this sort of overreach has come to be regarded as essentially un-American. Though modern U.S. history offers few precedents, such anti-press efforts have sadly become a hallmark of eroding democracies abroad. In places like India and Hungary, where we've seen an emerging playbook aimed at gutting independent news organizations. Prior to Trump's reelection, I wrote an essay for the Washington Post urging others in my profession, which has already been badly weakened by declining revenue and technological intermediation, to study this playbook so that they could prepare to defend against such efforts on our own soil. Since then, a number of news organizations have indeed risen to the occasion by pushing back on the Trump administration's efforts to attack and punish independent journalism. That's important because without brave clients, good lawyers can neither assert nor defend the rights of a free and independent press. Some news organizations have sued to vindicate their rights, like the Associated Press over the White House access, and NPR over funding cuts. Others, like the Journal, have stood by their reporting in the face of retaliatory lawsuits. I'm proud to say that the Times has done both. Then there are media leaders who have settled winnable cases to appease the administration or advance their business interests. Those who have transformed their editorial pages to placate the president. Those who have let the president rewrite their style guides, telling themselves that it's harmless to swap out the Gulf of Mexico for the Gulf of America to avoid something worse. Those who have written unusually large checks for the benefit of the president. Such capitulation, even seemingly small instances of it, serves to only embolden the administration to keep attacking the press. But let me end on a note of optimism, with a reminder of the path we hope our nation one day returns to. Several years ago, the Times won a Pulitzer for a series that exposed the civilian death toll of U.S. airstrikes overseas. The work took more than 5 years to report, often in places so dangerous the Pentagon wouldn't send its own soldiers there. The revelations were devastating. Hundreds of dead never tallied by the military, little effort to investigate mistakes or bad intelligence, an internal culture of impunity. We showed this pattern held all the way through the very last airstrike of the 20-year war in Afghanistan, an attack on a suspected terrorist that killed 10 people, none of them terrorists, 7 of them children. The revelation was initially met with the usual bluster and denials. The military called it, quote, a righteous strike. Eventually, Pentagon officials were forced to admit what our reporting had undeniably shown, that their righteous strike had in fact been, quote, a tragic mistake. A package of reforms soon followed. Now, it would be an understatement to say that the Biden administration was no fan of the Times. The White House believed, among other things, that we were far too aggressive in covering questions about the president's age and fitness. And perhaps fearing such questions, the president refused to sit with our reporters for a single on-the-record interview during his term. Yet months after our airstrike reporting was published, the Defense Department press secretary did something extraordinary. At a Pentagon briefing, he publicly congratulated the Times for winning a Pulitzer Prize for the work. He said, and I quote, "I cannot say that this process was pleasant, but I guess that's the whole point. It's not supposed to be. That's what a free press at its very best does. It holds us to account and makes us think, even as it informs." And that recognition, praise even, amounted to a remarkable expression of tolerance for the uncomfortable, sometimes adversarial role of the press. Even those who chafe at our questions, who lament at our revelations, can sometimes, with clear eyes, see the value that such reporting provides. Now, that may be asking too much in this particular moment from this particular administration, but the press must carry on, as it has in previous moments of pressure, with faith in the power of reporting, the public we serve, and in the idea captured by the founders and echoed centuries later by Judge Friedman that the truth will always matter. I want to express my gratitude to all of you for your role in defending America's free and independent press. Without your tireless, fearless counsel, my profession would surely stand on shakier ground. So thank you.
That was pretty good, huh? Well, speaking of milestones, by the way, I'm Lee Levine. I'm the managing director of the Press Clause Coalition. Speaking of milestones, I want to wish you all a happy Bartnicki Day. Today is the 25th anniversary, believe it or not, of the Supreme Court's decision in Bartnicki versus Vopper. For those of you who don't know about it, in a case seeking to hold a media defendant liable for broadcasting the contents of a telephone call unlawfully recorded by someone else, the court held that a stranger's illegal conduct does not suffice to remove the First Amendment shield from speech about a matter of public concern. There were both press and non-press defendants in Bartnicki. Still, the court's decision had its most significant application to the press, which regularly publishes information from sources who themselves are prohibited by law from acquiring or sharing it. In this sense, Bartnicki and New York Times versus Sullivan share something in common. In Sullivan, although the case also featured both press and non-press defendants, the decision largely represented the court's response to Alabama's efforts, as our speaker mentioned, to drive the northern press out of the state. In Bartnicki, hovering over the case was the vital question of whether and when the press can be prosecuted or held liable for publishing classified or otherwise confidential information unlawfully provided by a source who wasn't supposed to share it. Bartnicki resolved that issue, at least in significant part. Nevertheless, it expressly left open another equally important question. When, if at all, does the First Amendment protect the act of news gathering, separate and apart from the subsequent publication of newsworthy information so acquired? We are here this evening to talk about the Press Clause. Especially after Bartnicki, I submit the most important reason that clause must have independent force is the Supreme Court's penchant for asserting that the Speech Clause does not protect the press from liability, criminal or civil, for engaging in conduct that violates a law of general applicability when such a law is invoked to punish the gathering of news. As a result, the court has held that journalists typically cannot shelter under the First Amendment when, for example, they attempt to protect their confidential sources from governmentally compelled disclosure, or determined to reveal source identities when they are newsworthy, or their newsrooms or homes are raided by government agents seeking to access their unpublished work product. For the same reason, even after Bartnicki, lower federal courts have largely assumed that the First Amendment does not preclude the prosecution of journalists under the Espionage Act when they obtain, rather than publish, classified information from government sources, or from a civil judgment against them for recording images and conversations, even in public places, without the subject's consent. Still, other appellate courts have been left to perform constitutional gymnastics to justify holding that the act of recording police officers performing their duties in public is in fact speech. There was a time, not long after the Supreme Court incorporated the First Amendment into the 14th and applied it against the states, when every justice sitting on that court subscribed to the then unremarkable view that the press clause actually protects the press. Look no further than Grosjean versus American Press Company. In that 1936 decision, a unanimous court held that a Louisiana statute that imposed a punitive tax only on the state's largest newspapers violated the freedom of the press, not the freedom of expression, not the freedom of speech. In Grosjean, the court explained that the predominant purpose of the press clause is to protect an untrammeled press as a vital source of public information. The Louisiana statute violated the press clause, Justice George Sutherland wrote for the court, because a free press stands as one of the great interpreters between the government and the people, and to allow it to be fettered is to fetter ourselves. Those are the court's words, not mine, which brings me to why we're here this evening. To be blunt, the Press Clause Coalition aspires to return the press clause to the place it occupied in our constitutional jurisprudence almost a century ago. It seeks to fill a void in legal advocacy on behalf of a free press, a void that threatens the core democratic functions that journalists and news organizations perform every day. The coalition aspires to enshrine in the press clause the fundamental notion identified by the Abrams Institute in the report that Sandy and Floyd talked about, the press clause, the forgotten First Amendment, that, and I quote, "The press matters, not just for those who carry out the work of journalism, but for a democratic society that is necessarily reliant upon the press to inform its decision-making and hold power to account." As set forth in our mission statement, the coalition plans to accomplish this by monitoring and identifying existing and potential litigation in which press clause advocacy may be appropriate, coordinating with counsel the prosecution or defense of litigation advocating press clause related rights, as well as the preparation of friend of the court briefs in support of them, serving as a clearinghouse through which press clause related developments and information are disseminated promptly to media lawyers and other stakeholders, supporting the Abrams Institute and promoting press clause scholarship, conferences, symposia, workshops, and other legal and publication programs, and developing strategies to build broad, nonpartisan support for press clause-based protections, including through bench bar initiatives, continuing legal education programs, and presentations at judicial conferences and judicial training sessions. Since its launch in January, the coalition has already, as Sandy mentioned, worked with the Abrams Institute to organize a symposium this fall at Yale Law School in collaboration with the Yale Journal for Law and the Humanities. As Sandy mentioned, that symposium will feature the presentation of several new academic papers focusing on the press clause, all of which will be published next spring in a dedicated symposium issue of the journal. We have established listservs comprised of more than 230 media lawyers and scholars with a demonstrated interest in press clause advocacy. If you are not already on one of those lists and would like to be included, please contact me. We have coordinated with Media Council in multiple existing lawsuits for the introduction of press clause-based arguments in their advocacy, both through consultation and through the filing of friend of the court briefs in support of their clients. You'll hear more about that from members of our steering committee in just a few moments. We have commissioned the preparation of a practitioner's guide to press clause history and advocacy, which is scheduled for release next year. We have created a digital library containing judicial decisions, briefs, and published scholarship addressing the press clause, hosted by coalition member the Media Law Resource Center on the public-facing portion of its website. We have undertaken the preparation of a dedicated continuing legal education program devoted to the press clause to be made available to media law practice groups at law firms, in-house legal departments at media companies, bar association media law committees, and judicial conferences and training programs. If you are interested in such a program, by all means, contact me as well. There is more, but in the interest of time, I'll leave it at that for now. Let me just conclude by observing that the Supreme Court's mixed messages about the viability of the press clause over the last 100 years have understandably caused litigants, especially in recent years, to shy away from invoking it. That fact, however, has a silver lining. It opens the door for those same litigants to do so now, and it frees courts, including the Supreme Court, to consider the press clause's applicability afresh. When it does, the court will be well served to heed the advice offered some 90 years ago by Justice Sutherland on behalf of all 9 then serving justices, which included not only the likes of Brandeis and Cardozo, but also McReynolds, Van Devanter, and Butler. That when the framers included the press clause in the Bill of Rights, their, quote, predominant purpose was to preserve an untrammeled press as a vital source of public information. Before I introduce our panel and our moderator, I think it's appropriate to just acknowledge the passing of a member of our bar, Bruce Sanford, who passed away, I believe, yesterday after a long illness. Bruce, at least several of us in this room got our starts in media law working for Bruce. And if nothing else, through his progeny, I guess we could be called, he left quite an impact. I'll now introduce Dave Schultz, my friend, former law partner, and current director of the Media Freedom of Information and Access Clinic at the Yale Law School. He represents both the Abrams Institute and the Free Expression Legal Network on the Press Clause Coalition Steering Committee, and he will introduce and moderate our panel. And panelists, please come up. Thank you.
The assigned seats, so there's chaos here. So thank you, Lee. Are these mics working? Good, okay. Thank you, Lee. And it is really great to see so many media lawyers and First Amendment litigants in the room, because you are the people who are going to resuscitate the press clause if it's possible to do that. So it's really important that you're here. And I should just note that the Abrams Institute, created by Floyd, in large part by Floyd at Yale, the mission of the Institute, which some of you may not know, is to bring the academy and the bar together. So I think this is a real great example of just the value of that institution in bringing together scholars who have been thinking about this over the last couple of years, and now bringing it into the world through, hopefully through you. And I think our assignment, as I understand our assignment on the panel tonight, is to explain why the Press Clause project is something you should support. Why, not just why it's needed, you've heard that already, but why it's reasonable to believe that we can have a major impact in moving the law in a direction that will ensure that we have a press that is vital and can serve democracy and is not just a lapdog to our government. And so what we're going to talk about tonight is what are those things, the functions that the Press Clause uniquely covers, and how do we convince people of that? And we have an incredible panel here tonight. Each of the panelists, and we have one more who I'll mention in a minute, represents one of the organizations that is part of this new Press Clause Coalition, but they're also amazing media lawyers and First Amendment litigators. Most of you know these people. I'm not going to go long into introductions, but just starting from my right, your left at the end here is John Paul Jassy, who's a partner in Jassy Vic Carolyn and has a nationwide practice with an emphasis on First Amendment, media, internet, and entertainment areas. Next to him is Lisa Zeikerman, the vice president of legal programs at the Reporters Committee for Freedom of the Press, a very important organization that most of you know. And Lisa supervises a team of about 20 lawyers that provide pro bono legal services to journalists and documentaries. And of course, before joining the Reporters Committee about 5 years ago, she too was a media and First Amendment litigator. And then next to Lisa, many of you will know, is Anna Daikun, who is a senior staff attorney at the Knight Institute and is the managing attorney of their fellowship program. And before joining the Institute, Anna was a fellow with the National Security Project at the American Civil Liberties Union. And the empty chair we're reserving for Bob Korn-Revere, who many of you know. Bob is currently the chief counsel at FIRE, the Foundation for Individual Rights in Education, and has been a First Amendment litigator for more than 4 decades. And in a prior life served as chief counsel to the FCC. So he'll be bringing some interesting angles to the discussion tonight. Bob amazingly had a 2 o'clock argument before the New York Court of Appeals in Albany and was going to run to the train station to catch a train at 4 o'clock and plans to be here before his time to speak. So we'll see if he makes it, but he certainly is dedicated to do that. So just a bit of table setting. You've already heard kind of what the mission or the purpose of this project is. And it really arises from the fact that over the past 40 years or so, the Supreme Court has all but read out the press clause from the First Amendment. As Sonia West and Ronell Anderson Jones have documented in a series of articles and legal research, the decline in references to the press, the decline of even mentions of the press clause in cases where it clearly is relevant, and rooting many holdings over the years for news organizations on a variety of issues in the speech clause, rather than talking about it as a press right. I'm not a historian, so I shouldn't probably be saying some of these things, but I attribute the antipathy of the press over the last 4 decades to certain political factions that emerged during the Vietnam War and the Watergate era, and antagonism towards the press that began in the 1970s with grievances about liberal bias and has blossomed today into the labeling of reporters as enemies of the press. So the court's movement away, we had in the 60s, New York Times versus Sullivan, and in the early 70s, the Pentagon Papers case, that same era, Mills versus Alabama. These were all important press freedom cases that were decided with reference to the press clause. Maybe not Sullivan so much, but certainly the Pentagon Papers, certainly Mills versus Alabama were clearly press cases. But at the same time, in the 1970s, and all the social turmoil and the change in the court, there were a series of cases brought to the court by media organizations in the 70s arguing for a First Amendment right of access to prisons. It was a big issue at the time. So in 3 cases decided over 4 or 5 years, the court in each instance where the argument was being made that there was this constitutional access right that was being violated by keeping reporters out of prisons, the court turned the question before it from a question of whether there was a First Amendment right of access for reporters to a question of whether reporters had special rights. And it typically would sidestep the question of whether there was some minimum public right, but concluded that as long as the press was not treated differently from the general public, it couldn't complain. And even went so far in the third of those cases, Uchin versus KQED, of kind of suggesting that there was no First Amendment access right in the First Amendment. describing in a plurality opinion that only had 4 justices signing on, suggesting that, the First Amendment is not a Freedom of Information Act. So, why are you bothering us? Now, that opinion and that holding of a plurality was essentially overruled, not exactly, but discounted, disregarded just 2 years later in Richmond newspapers, where again, the question was, this time instead of prisons, the journalists were demanding a right of access to courts. And the court, by a 6-3 vote, finally said, yes, there are certain governmental proceedings where the press has a right to be present, but even then, they wouldn't call it a press right. Chief Justice Berger, who wrote the opinion in articulating where this right comes from, kind of throws off in a backhanded way. It doesn't really matter whether we call this a news gathering right or an access right, but it is a right that comes from can be implied in the right of speech, the right of the press, and the right to petition the government, that you have to have certain information and you have to know what's happening in certain proceedings, and certainly proceedings where the power of the government is being applied to individuals. The general public has a right to know how that's being done. But the court was very clear in Richmond newspapers, this is a public right. It's not a right confined to the press. And then we have the ensuing decades where this has kind of disappeared. So a primary effort of this press clause project, as Lee has articulated, is to advance the notion that the press clause uniquely extends certain protections that are essential for effective journalism. And that journalism, of course, is essential for democracy to function. And that is the reason we have the press clause, that the ability to gather news, to curate the news, we often overlook that a key role of the press plays is to define the issues of the day. If you just had all the facts but didn't have them curated for you, you wouldn't really know what was important and what wasn't. So it's not just news gathering, it's the curation and it's shaping of public discourse are all protected functions. At least that's what we want to think about tonight. And we thought we'd start by asking each of the panelists to identify a particular right or function that journalists need to have protected that should be considered within the scope of the press clause, and make that concrete by explaining how that right or the recognition of some protection for that function would be relevant to a current controversy. So I'm going to just start with JP and move down the line. And why don't you just each go? And once we go through all these, we'll have an opportunity for some questions and further discussion. But this is to kind of lay out some of the functions that should be protected.
Thanks. And I just want to say what an honor and it is to be here with such an august group. I mean, there's so many legends of the media bar here. And so thank you for having me. So I'm going to be talking a little bit about using the press clause to protect journalists from having to reveal their sources. There was a recent incident at the beginning of this year involving a reporter named Hannah Natanson for the Washington Post, and Mr. Sulzberger mentioned her case. On the morning of January 14th, FBI agents executed a search warrant for her home, and they seized her phone, her Garmin watch, her personal laptop, and her Washington Post issued work laptop. Now, Natanson was not the target of the investigation, the government says. The target was a Pentagon worker who had top secret clearance and was charged with leaking classified information. But consider what was on those devices that belonged to Natanson and the Post. The Post told the court that they contained years of information about past and current confidential sources and unpublished news gathering materials, including reporting Natanson was actively working on. After the Doge firings, she was contacted by 1,100 sources, current and former federal employees who trusted her with their stories, and the FBI walked out with all of it. On February 24th, Magistrate Judge William Porter ruled on a request from the Post to get the materials back and also to stop the government from reviewing the materials. Porter blocked the government's plan to have a DOJ filter team sift through the devices. His language said, quote, allowing the government's filter team to search a reporter's work product is the equivalent of leaving the government's fox in charge of the Washington Post's henhouse, end quote. So why does the press clause matter for the reporter's privilege? Well, as Dave was saying, of course, the First Amendment protects both freedom of speech and of the press. And so there is a distinct reason why we are here and why we're talking about invigorating the press clause, because without a press clause that's robust and protects confidential sources, we are diminished in our ability to have a strong media act as a government, as a check on government power. And when the government can seize a reporter's devices or compel testimony about unpublished material and source identities, it doesn't just burden one reporter, it breaks down the entire system. Because the Post's attorney told Judge Porter, and this is just one example, it's not hard to imagine, that since the seizure, Nathanson's sources have dried up. That's the chill, and it's working in real time. Here's the doctrinal problem for all of you who know and are obviously familiar with the Brandsburg versus Hayes case in 1972. The Supreme Court split 5-4, and it was Justice Powell's concurrence that put over the edge the idea that there is not a protection that is rooted in the law. But the good news is there is a patchwork that came out of the dissent that several federal circuits have picked up on to recognize a qualified reporter's privilege that's rooted in the First Amendment. Now, we know there's no federal shield law, and the Supreme Court has not revisited the question in over 50 years. But a revitalized press clause could fill that vacuum for source protection. And my brilliant partner, Matt Schaefer, who couldn't be here because of a family emergency, he and I are working on an article with an idea for how to do that. About 3 weeks ago, the U.S. Supreme Court issued a unanimous decision called First Choice versus Davenport. In that case, the New Jersey Attorney General had subpoenaed a religious nonprofit for personal information about its donors. The nonprofit sued in federal court before the New Jersey Attorney General's subpoena was even enforced. The U.S. Supreme Court held unanimously that the mere issuance of the subpoena was a constitutional injury because it would deter donors from associating with the organization. Here's the court's language. Quote, demands for private donor information burden First Amendment rights, even if there is no disclosure to the general public, end quote. And, quote, an official demand for private donor information is enough to discourage reasonable individuals from associating with a group and to discourage groups from expressing dissident views, end quote. Now take that quote and substitute newspaper for nonprofit and source for donor. The analytical structure is the same. A subpoena or a warrant that's aimed at source identifying material discourages sources from associating with a reporter and discourages reporters from pursuing stories the government disfavors. The chill itself is the injury. And I want to be candid, this argument's not entirely new. In United States versus Caldwell, which was one of the cases that was consolidated into the Brandsburg decision, the Ninth Circuit quashed the grand jury's subpoena to New York Times reporter Earl Caldwell, finding that his testimony would severely damage his confidential relationships with members of the Black Panther Party and other militants who he was reporting on, and thereby damage his ability to gather, analyze, and publish news stories concerning them. That is almost word for word the associational injury that the Supreme Court discussed in the First Choice case. But the Supreme Court reversed the Ninth Circuit in the Caldwell decision in Brandsburg, with Justice White dismissing the chilling effect argument by reframing it as a request to grant newsmen a testimonial privilege that other citizens do not enjoy. As Dave was mentioning, that's how the question has been framed by the U.S. Supreme Court and many courts since. What is different now is that there has been a development of jurisprudence on the associational rights front, which is also derived from the First Amendment, that has developed in the past 50 years since Brandsburg, culminating in the decision 3 weeks ago in the First Choice case. 9 justices, a court that rarely agrees on anything, unanimously agreed that this was something worth protecting. The press clause is the textual home that the framers gave us. And we're hopeful that maybe first choice is an avenue or a hook, a doctrinal bridge that the court has built that we can use to reinvigorate and breathe some new life into the press clause when it comes to the reporter's privilege.
Hey, everyone. Thank you again for having me as well. I'm going to talk a bit about access under the First Amendment and how the press clause is yet another avenue for confirming, affirming, expanding reporters' access rights to observe proceedings, government proceedings. The Reporters Committee attorneys spent a lot of time last winter after the press clause convenings trying to think of ways in which on the ground we could employ some of the great ideas from those convenings into actual application and good work for our clients. I'm going to talk about a topic that's a little bit sensitive, and that sensitive topic is lethal injection and executions carried out by many states, actually, in our country. We anticipated that in the year 2025, many states that execute their citizens were going to begin doing so, whereas many execution proceedings had been stalled for a number of years for a variety of political reasons. Two of our staff attorneys work in states that execute their citizens. One is Tennessee and one is Indiana. Each of those states have statutes and regulations in place pertaining to who may witness execution proceedings. Each of those statutes, we believed, unfairly restricted press access, the access of neutral observers to witness execution proceedings. And we wanted to do something about that. I'll start with Tennessee. And enormous credit, I should say, to my colleagues, Paul McAdoo, who resides in Tennessee and works on media issues with us. Beth Soja, another attorney at the Reporters Committee, Allison Viley, all worked and contributed on this litigation. In the state of Tennessee, the state execution statute provides that press may witness execution proceedings along with other designated witnesses. But the period in time in which the press can witness an execution proceeding is quite limited. And this is the sensitive part. So I'm just preparing anybody who has sensitive ears. Most executions in the state of Tennessee take place by lethal injection. The preparation of the condemned begins out of sight of any observer. Medical personnel who are employed by the state identify a vein in which they can employ a port to eventually provide the lethal injection of pentobarbital. That procedure takes place outside the view of any witnesses. The beginning of the injection is somewhat obscured as well. Some observers notice that a rock is sort of placed by a disembodied hand at a point when it's quite possible that the injection drugs have been inserted or have started to run, but that's hard to say. But for any witness who wants to observe or is present to observe an execution by lethal injection in Tennessee, essentially you're in a room, there's a glass window, there are curtains, and for 15 minutes, the curtains open, and 15 minutes elapse and they close. And all that you see, or that one can see during that time, is the condemned strapped in a gurney. Most of their body is enshrouded in a sheet. You do not see the medical personnel whatsoever who have employed the IVs and the pentobarbital. You may see the condemned with a spiritual advisor by their side, and that is it. The moment of death is not necessarily witnessed by anybody, and it is quite limiting in the press's ability to perform its function of being neutral observers to what I would consider the apex of the exercise of government power. We challenge the statute and this limitation, and by we, I mean a coalition of news organizations, and I want to give them credit for stepping forward in this case. The Associated Press, Gannett, Nashville Public Media, Nashville Public Radio, Scripps Media, Six Rivers Media, and Tegna all joined a coalition to challenge this limited access under three different theories. One was that the statute itself in Tennessee that provides for this degree of access permits by law that 7 members of the press be entitled to be present at the carrying out of the death sentence to stand in the shoes of the public and provide an accounting of what occurs. We challenged the current regulations that limit that opportunity to 15 minutes as a violation of the statutory term itself. We also brought a traditional First Amendment access case under Press Enterprise 2. And thirdly, and what I think is most interesting, just in terms of developing case law around the press clause, is we also brought a claim under Tennessee's own constitution. And I'll read you that provision. Article 1, Section 19 of the Tennessee Constitution states that the printing presses shall be free to every person to examine the proceedings of any branch or officer of the government, and no law shall ever be made to restrain the right thereof. To our mind, this is pretty strong press clause-y language. The history of the Tennessee provision comes from the Pennsylvania Constitution. In fact, we have a resource of all state constitutional provisions that mirror the rights inculcated in the First Amendment. And we're very interested in bringing more claims that assert those rights. In the case of in Tennessee, we sought a temporary injunction to allow our clients to view the entirety of death penalty executions in the state, and we were successful. The court in our case concluded, first of all, applied Press Enterprise 2, which was rubric, which was fascinating. And I'll get a little bit to that in a second. Concluded that was the correct test, the correct constitutional test, and determined that the state statute impermissibly limited constitutionally protected access that the press required under the statute to witness executions. Aside from the Ninth Circuit and I think the Middle District of Pennsylvania, I think this is the only other court in the United States to have so found a right to access execution proceedings under Press Enterprise 2, which is fabulous. But because the court took that route, it declined to apply the state constitutional provision. The state of Tennessee has appealed. Paul, will be before the Tennessee Supreme Court this summer. But I want to sort of underscore the practical importance of this case. Today's a great day because it's Bartnicki Day. On the other side of the ledger, very far, far away, in Tennessee, there was a man who was slated to be executed today by lethal injection. And some people may have gotten the New York Times push notification about the outcome of that effort today. What occurred was, according to both the state and the condemned's attorney, is that the staff of the Department of Corrections were unable to locate a vein to initiate the lethal injection protocol. And as a result, the state decided to basically postpone the execution for 1 year. I conferred with my colleagues this afternoon and said, okay, how do we know that that's actually what happened? Because of the limitations of Tennessee's execution access protocols and the limitation on access for reporters or any other observers to witness these proceedings, there was no neutral observer who saw what occurred when these attempts were made to insert an IV into the condemned's arm. And that's precisely the problem that we're going to try to solve and continue to win on, hopefully, in the Supreme Court of Tennessee. The other case that we brought is quite different because of a very, very different state law. There are 27 states currently that execute their citizens. 2 of them forbid any press from witnessing those executions. One is Wyoming, and is almost inconsequential presently, or at least of no practical effect, because the state of Wyoming hasn't executed a citizen since the early 1990s. But the other state, Indiana, is currently engaging in death penalty executions of their citizens, again, using lethal injections through the provision of pentobarbital. In fact, the state statute that sets forth the protocols for access to witness those executions is very deliberate in excluding members of the press. It states that the witnesses to the executions may include spiritual advisors, a doctor, victims' family members, and the condemned's family or friends, totaling maybe 5. The regulations adopted by the Department of Corrections take this information and explicitly exclude members of the media from witnessing executions in Indiana. We wanted to challenge that, and we did so in federal court last spring in an action led by my colleague Lynn Weeks and Chris Cundiff, based in Indiana, and again, Beth Soja. And in that action, we brought two claims. The first was, again, a press enterprise to access claim. The second was a cause of action pursuant to the press clause. And that cause of action built on the decisions of the Supreme Court in 2021 in a couple cases that were essentially about free exercise of religion that we thought would be very helpful. And I'd like to build on my friend JP's analogy earlier. So in Tandem v. Newsom, a case in which the court enjoined a COVID-19 restriction that prohibited in-home gatherings, secular and religious, of more than 3 households, but exempted larger gatherings in commercial spaces, the court declared that, quote, government regulations are not neutral and generally applicable and therefore trigger strict scrutiny under the first free exercise clause whenever they treat any comparable secular activity more favorably than religious exercise. So we'll do your trick again. The court declared, we hope at some point in the Seventh Circuit, that government regulations are not neutral and generally applicable and therefore trigger strict scrutiny under the press clause whenever they treat any comparable secular activity more favorably than press work or press access in this case. So the theory in our case is that the statute and regulations in Indiana disfavorably treat the press and intentionally exclude them from witnessing executions, whereas it permits otherwise non-press individuals to witness those executions. I have a lot to say about this case, but I've spoken quite a lot already. So I will leave you all then with just 2 things. Firstly, in Tennessee, we look to the legislative history of Tennessee statute to figure out how best to describe to the court the intention of the legislators in ensuring press access to witness executions as part of our statutory argument. And we found this quote from a state senator who spoke in favor of the bill in 1994. And they said, whether you're for capital punishment or not, when the state exercises that very awesome power, it's imperative that we have media there to witness it, not just to promulgate and to spread the news that it's been done as a deterrent, but to also make sure that the state exercises that awesome power with the highest level of decorum and that it's carried out appropriately. As part of our extensive research in support of our Press Enterprise 2 arguments, in order to fill out that history prong, we did, and by we, again, I mean my exceptional colleagues, did incredible research demonstrating that state after state after state in the late 1800s and in the early 1900s, when public executions moved out of very, very public spaces into jail yards, that those initial public laws, so moving those executions into more closed spaces, consistently required the presence of journalists. So that the awesome act of executing a fellow citizen would be observed by neutral members of the press and shared with the public. And so if anybody's trying to build press clause arguments, I think that history has a lot of rich uses going forward inside or outside the execution access space.
Well, hi, good evening all. I'll echo my co-panelists to say that it's an honor to be here tonight, and I'm thrilled to be part of the coalition and really looking forward to see what we can accomplish together. So tonight I'll be talking about the potential role of the press clause, what it can do to protect news gathering, particularly in the context of protests. But first I want to set the scene a little bit so we all know what we're dealing with here. In the past 5 years, hundreds of journalists who were covering peaceful protests or acts of civil unrest in the United States have been arrested, physically assaulted, had their equipment damaged, or were otherwise forcibly restrained from doing their work that they were there to do by members of law enforcement. And it's certainly true that in many of these instances, reporters were caught up in the fray, perhaps hit by projectiles that were indiscriminately fired into the crowd, which is a separate issue, or caught up in a kettle and detained that way. But very troublingly, there are a number of documented instances where it appears that press were targeted precisely because they were press, because they were there to document what the law enforcement is doing. And just to make this a little bit more concrete, I have some numbers from the US Press Freedom Tracker, which is a project of the Freedom of the Press Foundation and really a terrific resource for information about this. So last year in 2025, the tracker documented 195 assaults on journalists who were engaged in news gathering, and many of those happened during protests. And as for arrests and detentions, the tracker documented 35 instances where members of press were arrested, charged, or detained, and 90% of those approximately happened during protests. And of course, the more protests there are, the more assaults and the more detentions and more confiscation of equipment, et cetera. So if you look at the 2020 numbers, for example, they're off the charts. And even if those, temporary detentions don't result in charges or arrests, for example, it's important to note that they can have serious consequences too, because then what that means is journalists are being taken off the streets, prevented from news gathering, and it may dissuade other journalists from going to document those same protests. And so one high-profile case that many or most of you are following, I'm sure, is that of Don Lemon and Georgia Fort, who were arrested at the end of January this year following their coverage of an anti-ICE protest at the city's church in Minnesota. So along with dozens of protesters, Lemon and Fort were charged with violations of the FACE Act, which is the Freedom of Access to Clinical Entrances Act, for allegedly injuring, intimidating, and interfering with the exercise of right of religious freedom at the place of worship, and also for conspiracy against the right of religious freedom at a place of worship. So this use of the FACE Act appears to be unprecedented. This law has historically been used to protect the rights of women who are seeking access to reproductive care. And though we do at times see journalists charged with trespass, for example, in similar situation, almost always those charges are dropped. And more likely those charges haven't been brought in the first place. So while the protesters, the press are alongside may be charged, very often the press aren't. And that's attributed largely to prosecutorial discretion. And we seem to have entered an era in which we can't take that kind of prosecutorial discretion for granted. And notably, in that case, a federal magistrate judge initially declined to issue arrest warrants. And then the government took it up to the appeals court, and the appeals court also rejected that attempt. But then they went to a grand jury, secured an indictment, and subsequently Fort and Lemon were arrested. So this brings us to the question of the press clause. What can it do in that situation and other situations to protect the rights of the press who are doing their job, which is quite often a dangerous job at these protests? So in the Lemon and Fort case, they both have very strong statutory arguments and also constitutional arguments in their defense. And the government will need to show that they had specific intent. A robust press clause would, of course, make it all the more obvious in this situation that the reporters, Lemon and Fort, who were there just to do their job, to engage in news gathering, did not have the requisite intent to commit the crimes with which they are accused. But thinking more holistically about the rights of press at protests, beyond that case, what work could the press clause do? And so when I'm thinking about this, what I'm thinking of is, in what circumstances may it make sense to recognize a specific right for the press that we wouldn't necessarily need to give to the public themselves? And I think protests in particular give several scenarios that are really a strong use case for the press clause. So first, we have curfew orders. In 2020, for example, during the Black Lives Matter protests, nearly 150 cities instituted curfews. Most of those did exempt media from their orders, but several did not. And I believe in all of those cases, they ended up reversing course in the face of public outcry from the media and advocates. But what that incident made clear is that there is not a well-established constitutional right at this point for press to disobey or to be exempted from curfew orders. Second, and in a similar vein, we have equipment ordinances. So many cities put into place ordinances that restricted people from bringing certain equipment to the protests, for example, tripods or ladders. There's a strong argument to be made that the press needs certain equipment to be able to document what's going on, to capture the full scene, so that the public can be aware of what's happening at this protest. And while some of the ordinances did exempt media, again, we're seeing a theme, some did not. And so third and finally, the press clause could be used to firmly establish the right of the press to remain behind police lines, even when a valid dispersal order has been issued. The idea behind this is simple. If journalists aren't allowed to remain, then all that we're left with is the government's narrative of that, claims that it properly issued this dispersal order and then smoothly executed it in full compliance with the law. And in Judge Simon, in a District of Oregon case in 2020, an Index Newspapers case, recognized in one of his opinions the special nature of the press and why it was so important, why they were so important here. And he noted that the point of journalists observing and documenting government action is to record whether the closing of public streets, e.g. declaring a riot, is lawfully originated and carried out. Without journalists, there is only the government side of the story. In that case, he noted that because the city and the plaintiffs had entered into a stipulated agreement to that the city would not remove members of the press, there was no need for him to consider the question of whether press had rights over and beyond those of the public. But while he said today is not that day, he acknowledged that one day the time may come. And so I'll stop there. But these are just some instances where the press clause could do real work that the speech clause does not. And I think that they're worth exploring.
Well, thank you all. I was going to say don't stop because Bob's not here yet, but maybe we'll move on a bit. I think this has been great. Your examples are really good. I think a couple of things that occur to me just to point out is that in each of these areas, we're finding that identifying press protections can be done by looking at analogies to others. We protect donors for certain reasons. We protect religious organizations. And saying, but wait, the press is in the Constitution too, and it's a separate and distinct right. And one of the things I hope all of you will think about is what are those functions? We've identified some here, right? Access rights, source protection, news gathering, but each of those has other variants. And one of the things that the Abrams Institute has done in this paper is try to tie a lot of these arguments back to history. What did the framers understand the press did? And, you can frame them different ways, but one way to think about it is there was a watchdog function that they clearly recognized. They understood that. There's lots of language about how the reporting on the Tea Party and what happened in Boston, the fact that the newspapers picked that up and spread it around was what was able to gel public support. Well, that's two things you could say that they recognized the press was doing there. One was they were gathering the news. Three things. Two, they were publishing it, disseminating it. And three, they were deciding what was important. So that they were doing this curation function, right? So those are all things the press does. Now, what are the rights you would argue exist there? If you have the right to, if part of the press role is to curate what the public does, clearly editorial discretion and what goes into a paper, what goes onto the wire or over the internet by the press is a First Amendment protected activity. So it's a question of like, how do you formulate these things? You know, the watchdog function would include news gathering for sure, but maybe other things. The access issue can be talked about as a variation of public access, but to what extent is the press a proxy for the public where it can't get in? Executions are a prime example. So there is a function of the press acting as proxy, which itself should be protected in certain contexts, and it is. See, a lot of these things are protected. We just don't necessarily hold them up as press rights, right? There are press seats in courtrooms. There are press passes to get into Congress that people recognize that. And so I guess one of the things that I think is important is to start thinking about these things as press rights and articulating them affirmatively that way. Even, I don't know if David McCraw is still here, but even in the New York Times Pentagon Papers case, right? It's argued, there were a number of arguments, including due process, but one of the prime arguments is the Pentagon is a designated forum for First Amendment activity, and the court agreed with that. And therefore you can't limit that First Amendment activity in ways that are unreasonable. And the basic argument was reporters are there to gather the news. So it's implicitly saying news gathering is a First Amendment protected right. And you can't say to reporters, you're not allowed to ask questions because that's an unreasonable restriction on a First Amendment activity. So it's really just framing. Having said that, I maybe will ask each of you to since you can, to comment on in your particular area, how do you tie what you want to argue back to, or can you, back to history and make originalist arguments? And maybe JP, I'll ask you to go first, because I know this is sort of the focus of your article. But I think given the court we have now, the more we can say these are clearly evidenced in the historical record, the better off we're going to be. And it gets harder, I think, on some of the others, but.
Well, I think that one way to do that would be to give examples of situations where confidential sources were critical, and they really span the political spectrum, right? I mean, you've got, for example, Watergate. I mean, if you didn't have Deep Throat, we wouldn't have had all of that reporting. I'm not sure how much all of the, yeah.
I guess one of the questions I was trying to get at though is that particular source protection. One of the ways to argue it's First Amendment protected under an originalist approach is to go back and say, that's what the founders would have understood. You know, talk about the Zenger case and a lot of these things where protecting anonymous sources was the key thing.
Right.
And I guess the question is, are there threads like that in each of these areas, and how strong are they? Or is there not really, because I think to the extent you can come up with historical analogs, the stronger the arguments will be.
No, I think especially with this court, I think is your point. Yeah, I think the Zenger case is a good example. I'm not an historian. I don't want to.
That's why you're Matt.
Yeah, Matt's definitely the historian of the two of us. But he's, if you look at, there are many examples, as I understand it, going back to the colonial era and then in the early days of the Republic, where you have important stories that were brought out or brought forward by confidential sources, and there was a real reluctance by even courts to invade that. And I think you're right. I think that that is something that can resonate more with this court, and pointing to those examples and saying this is not unfamiliar territory. If we had the people who were there at the founding and they were to hear that there was not really meant to be any protections under the First Amendment or under the press clause for members of the press, they'd probably be surprised to hear that.
And Lisa, in the context of executions, of course, the history and logic test that gets you to access really forces you to look at history, right?
I mean, we did a lot of that research, as I sort of mentioned. The interesting thing when you apply the history and logic test, a lot of courts want to cabin access to criminal proceedings. They look at, Richmond newspapers look at the other cases and say, this is about courtroom proceedings. And the arguments we made in each of our cases was that, number one, it doesn't have to be so cabined, that there is great deal of historic record of access to witnessing execution proceedings in public from the founding of the country, and we cite sources on that. But also what we try to sort of underscore is that executions are not necessarily solely an executive branch function. Executions are set by the judiciary. The date is set, the method is set, so much is set by court order. The courts are, from the moment that the condemned is sentenced to death to essentially mere weeks sometimes or mere days before they are executed, when every last appeal is denied, the courts are very active in that proceeding. And so in addition to establishing a historical record of, since the founding of the nation, actual public access to witness execution proceedings, we've also made the argument, even if you want to call this the Press Enterprise 2 test, a test cabin to the ability of any one member of the public or the press to witness criminal proceedings, so too that would apply in the context of the ultimate finality of any criminal proceeding, the execution proceeding itself. And I also think that's one of the reasons why in our Tennessee case, we pulled language from the state constitution itself. And I think it's very useful language. I was quoting from it because the idea that the press should be free to examine the proceedings of government sounds an awful lot like Press Enterprise 2, but it was written in the 1700s. And that's fascinating to me. And that language actually in Tennessee was not written in the 1700s, but it was based on language written in the 1700s in the Commonwealth of Pennsylvania. And that's fascinating.
Right, and I'm a really a fan of this whole comparison to the religious cases, particularly given the current court, that this concept that sometimes called the most favored nation approach, that the court has said you can't treat religions less favorably than secular institutions unless you have a compelling interest. It's a strict scrutiny of why you're treating. Mm-hmm. But the press clause is right there next to the freedom of religion in the Constitution as a protected activity. And so where the analogy can be made in the Indiana case, which I think is a great example of that, the law specifically says certain people can be there specifically. Religious people, family members of the victim, family members of the condemned person, certain people that the warden has permission to designate, but the press is not permitted to be there expressly in the statute unless he's invited by someone who had the authority to bring something. So like in some cases, the condemned invited the press in. While
we were litigating the case, on the one hand, there had been an execution where one of our clients' reporters was invited by the condemned as one of their individual witnesses. And she describes in her declaration the enormous pressure of being the one member of the press to witness the execution. And then afterward, the next execution that occurred during the pendency of our litigation, the condemned did not permit a member of the press to join their group of witnesses. And thus the press were relegated to what is essentially the parking lot, which is where the press typically learns of that the execution has taken place. And what's fascinating is the state argued essentially that this is not a case analogous to those free exercise cases, because here the members of the media can just find a spot if they wanted to. And we argued in the Seventh Circuit, where the case is now pending, actually that would be like in those free exercise cases, you saying to the religious observers, well, the only way to get around that COVID-19 rule is then you just have your religious meetings in like public barbershops and other commercial businesses that were allowed to engage in larger gatherings during that COVID period, which would be absurd.
Yeah, no, it just seems to me like a great case to make that analogy. And I don't know, I'm curious about you, because I've always thought that the hardest argument for extending the press clause, or at least the most amorphous, is news gathering, right? And the basic hook, I think, that we have in current case law is in the Cohen case. It says essentially, the press is not immune from liability for laws of general applicability, But it goes on to say laws of general applicability that have no more than an incidental impact on news gathering, which leaves open an argument that when laws have more than an incidental impact, but it's hard. So that's one thing is like, well, what would be a case to bring that in? And the other is there are other analogies where things are happening, like in news gathering. There's been a lot of litigation of ag-gag laws in recent years that really get at the same sorts of concerns about news gathering, like laws that say you can't misrepresent that you're a report, that who you are, that you're with a crazy group that wants to stop meatpacking. When you get in, you have to disclose who you are. And an argument that that's a violation of the First Amendment right. I mean, reporters have long done things like send testers out to see if there's racial discrimination in landlords and misrepresent who they are. So have you thought much about like what would be a circumstance where you could be making a press clause argument to defend against a news gathering? I mean, it's different. It's a bit different in when the press is targeted, because then you have a retaliation claim, which isn't necessarily a press clause claim. You know, a lot of people could bring a retaliation for protected activities, like some of the protest cases out in LA where the press, and in Oregon, I think earlier, where reporters were targeted and were able to bring claims. I think one of the challenges in the Don Lemon and Georgia Fort cases are that at least the indictments are written as though they were just brought in because they were protesters. They're not. There's no specific mention that they were reporters, although it was obvious that Don Lemon was there with a cameraman. But they don't make it an issue of the indictment. So.
Yeah, well, you laid out a number of challenging issues, and I wish I had the answers for you. Instead, I'm going to maybe layer on a few more problems, which is hearkening back to the comments earlier today about the relationship between the press and the courts and the press and law enforcement and press and the public. I think we've seen all of them suffer. And there's a study that I think it was Sonia and Ronell that wrote it, documenting mentions of the press in Supreme Court cases over time and how press is invoked much less favorably in recent years than it has been in the past. And this comes up, time and time again in analyses of why there are so many more incidents between members of the press and law enforcement and members of the press and even public. And one thing about protests in particular is that the nature of protests and press reporting on protests has changed. So when we see these big 2020, Black Lives Matter protests, for example, that caught national attention, even worldwide attention, you saw members of the press flying in from other cities to do their reporting. And so whereas, decades ago, much longer before that, you might have a press that interacted frequently with members of the law enforcement, with their local courts, were really enmeshed in their communities and had that relationship built up. When you have repeat players, I would say, when you have the changed nature of news gathering in that way, those same relationships aren't there. And at the same time, we have the declining trust of the public, of the press. And in 2020, we saw not only more assaults on the press by members of law enforcement, but also by the public who did not want to be recorded, who didn't want to be interviewed, who didn't trust them to be in their midst. So I think those are just layering on top of the issues that you flagged, or why it makes it hard in today's terms to make an argument for that the press is special in the news gathering and protest context. I think going back to historical examples of the role that press traditionally played could only help. But I think it's a difficult challenge.
I think that one of the things that you were talking about earlier and Sandy brought up is the definitional problem of who is a member of the press. And I think that becomes most acute in the context of protests and news gathering because there's a concern, somewhat justified, I suppose, that anybody who's got an iPhone can say, I'm a member of the press. And there are ways to resolve that, I think. One of the ways that I don't think is a good way to resolve it is to have the government deciding who's a member of the press. But that also has its own tensions, because where do you get your press pass from? I mean, obviously you can get it from your employer, but if you're getting it from the police department or, you know, whoever, the sheriff or something like that, then you start getting into problems where, you know, I would imagine if we had somebody from the Department of Defense or Department of War or whatever we're calling it, that they would say, oh no, well, we do have reporters in the Pentagon. You know, these are the reporters that we think are.
It is the Department of Defense.
That's what I think too, but
Until Congress changes the law. But, no, these are issues and I just would throw out one other one. I often wonder in terms of pushing these issues, you know, relying on history. Maybe I don't want to go there. Where I was going to go is there are lots of common law analogies too. And the question is, how do you constitutionalize some of those common law principles? I think that the case you mentioned, the first choice is really interesting because they treated the protection of donors as a First Amendment right. And for all the same policy reasons, you would say protecting sources. But it also seems to me that there's a lot of, there might be, I mean, we've been around this many times because the court keeps rejecting this notion of a broader person. But, you know, some arguments that trying to urge the court to adopt source protection for reporters' sources as a common law right might be an easier push, which is why I'm curious, you know, in the sense that there are a lot of analogies you can draw, policy arguments you can draw. You know, there was a great quote I recall, and the city bar wrote a whole thing on this like 25 years ago, the need for a common law right, source protection. And there was a great quote from Attorney General Ed Levy. Most of you are probably too young to know who he is, but he was the Attorney General who came in after Watergate and cleaned up the Justice Department, a very respected, I think he'd been the Dean at the University of Chicago or a professor at the University of Chicago. Anyway, he gave testimony about to Congress about why the FBI has to be allowed to have confidential sources, which was the biggest. And then it basically is making all the arguments that you would make for a reporter, that that's the only way we can get information from certain people. And if we can't promise confidentiality and keep those promises, we won't be able to solve crimes. So, and this donor thing is another, how you take those arguments and put them together and then make it a constitutional imperative, bringing it back to why does the press clause exist?
Well, and just from a very practical perspective, for those of you who might be interested in how it played out. So the first choice decision was actually a 1983 case. And one of the things I think is fascinating about it is that the court said you can bring a 1983 action in federal court to stop the enforcement of a subpoena that was issued by a local or state governmental authority. And the evidence that they came up with in support of their motion for preliminary injunction, which ultimately the U.S. Supreme Court said was an available remedy, was two things. One, they had a declaration from donors, presumably signed anonymously, saying I would have been much less likely to donate. And the second was a declaration from the executive director of the First Choice organization saying we're afraid and we are losing members because people think that they're going to be outed and exposed. That, just from a very kind of practical nuts and bolts perspective, that's the kind of thing. And you take that kind of evidence, and I think it could lend itself to a common law type of designation. And look, you know, whatever progress can be made, that's great. The concern that I would have with that is that very often courts, I think, are trying to balance out competing constitutional rights, you know, and especially if it's, you know, for whatever the basis is that the subpoena's coming or the warrant's coming. And so it's good to have a constitutional comparator.
So there are a number of other issues we could go into. We don't have a lot of time left, but we might want to have questions. I would, one other point that we didn't get to, but I'll just put out there is, you know, identifying these rights and getting courts to think about them as things that are protected by the First Amendment will have implications not only for protecting reporters, but for procedural issues like who has standing to do things and have other areas where it's really important to get these down. And I think that that's another aspect. But let me just see if there are questions. If people here have questions, we'll use up Bob's time with questions from the floor. Floyd.
Lisa, I'm not clear what the state's position is as to why it is a good thing not to let the public to witness execution.
Well, I think their position would be that enough people witness executions. If we're talking about Indiana, their position is we have witnesses. They're just not, in our view, neutral observers. They are witnesses either designated by the condemned or designated by the victim's family, and that's it.
But there's some underlying position of the state that it's indecent, that full coverage, let's say, of execution, televised. What's the problem that they are asserting they're dealing with, not allowing the broadest possible distribution and photography and the like of execution?
Both the state of Indiana and the state of Tennessee asserted protections and security of personnel who carry out the death penalty. In other words, the hooded executioner looms large still in our society.
Yeah, no, it's really interesting. The point you're making, Floyd, is do you want to live in a society where you just say, okay, we're going to condemn people. The state is going to have the right to kill people. They're going to go behind a door and come back and say, okay, they're dead. And you don't know how it happened. And there's great historical arguments because historically, hangings were big deals. Everybody in town came to see the hangings. And when this controversy, I can't remember the exact case it came up in, but it was the right of access to something in California that got to the Ninth Circuit. And Judge Kaczynski wrote an opinion. I think it was dissenting from en banc, they declined to do en banc review. He thought they should and he basically said, the decision to kill somebody is like the most important thing the society can do. And people should understand what they're authorizing. And he said, my device of choice would be the guillotine. People should see it's good because it's quick and it's bloody and people should see the blood. So, it's just a question of.
In the Tennessee case, the trial judge who granted our injunction, part of the injunctive relief, the judge required the state to address its security concerns to ensure that their staff are wearing garb that covers their face, surgical garb, masks, head coverings so you can't see their hair, because the court took that as a fair issue that the state had asserted, but it could not completely overshadow the essential need for there to be a neutral observation of the entire execution proceeding.
So we're just about at time, unless there's some burning questions. I hope this has stimulated some thought, got you curious about when you might be able to insert these arguments into the cases you're handling, and built some fire in the belly to get out there and save a vital press for future generations, because it really is, the lights are going out around us in ways that I think we don't all quite appreciate yet. So I want to thank the panel for taking the time to come up here. Thank Sandy and Floyd for doing this effort.
Thank you. This is me. Thank you to the panel. Thank you to all of you. Now, we want you to go forth. Okay? This was not just an intellectual exercise, which is what Floyd and I used to talk about at the very initiation of the Press Clause Project. It requires all of you to please be in touch. We'll be in touch and you'll be in touch. Wasn't that Barbara Walters? But Lee is going to be manning this incredible team of volunteers, if you will, from the coalition. And with the coalition, we hope that you will think long and hard about using the press clause. Seek help from us if you want it. And one other one other thing I would really like from everyone, many of you are from New York, so it's something I'm looking for nationwide, which is looking into your state constitutions, your state laws, your state opinions to see what you can find. Because people who do that sometimes find some really interesting stuff that goes to the history that David mentions, which we have found to be extremely interesting and very useful. Again, thank you for coming. Thank you for being with us.